Welcome to the History and Overview of the Surrogate Decision-Making Committee, or SDMC. This is the first of 7 modules provided by the New York State Justice Center for the Protection of People with Special Needs. During this module, I will provide the history and overview of the SDMC program, treatment and procedure options, and who is considered a public officer. The Surrogate Decision-Making Committee is an innovative program that was created and governed by Article 80 of the Mental Hygiene Law. This law provides the framework or legal standards for SDMC procedures and standards for volunteers who will be making decisions directly affecting the individuals with special needs who come before the panel seeking informed consent for major medical procedures. Let's start with the history of SDMC. Prior to SDMC, individuals were waiting weeks, and even months or years, just for dental work under general anesthesia because the courts were so overburdened with other issues, and these cases seeking informed consent were not prioritized. At that time, the court system was the only means for an individual without capacity and without a legally authorized decision-maker to receive consent for a medical procedure. People with disabilities were not being treated in a manner that was consistent with their own individualized needs. There was also some frank testimony about providers that were allowing some people, who most likely lacked capacity, to sign for their own treatment as a means of bypassing the court process because it was so cumbersome. At times, physicians would accept the authorization of staff who were not truly authorized to provide consent, which was inconsistent with the doctrine principle of informed consent. Some providers were liberally applying the standards in the public health law that allows the physician to move forward in an emergency situation when they can't secure informed consent in a timely way. Even if a true medical emergency didn't exist, the procedure was identified as an emergency to avoid the delay due to the court system for informed consent. People with disabilities needed an alternative. SDMC offers many advantages over the court system. The process is free to all providers and patients, and there are no court fees. Individuals will remain eligible for SDMC indefinitely regardless of whether they continue to reside in an Office for People with Developmental Disabilities, OPWDD, or an Office of Mental Health or OMH program. SDMC includes the individual and their natural supports in the process. With very few exceptions, the SDMC hearing may only proceed with the patient present, and all interested parties receive notice of the hearing. The panel considers any preferences regarding the treatment or procedure which the patient may have expressed. Another benefit is that SDMC provides more timely decisions and access to health care than typically is provided through a court process. SDMC can generally process a case and hold the hearing for informed consent within 14 days, but in some urgent cases, hearings have been held the same day the declaration was received. Due process rights are also recognized with appropriate notifications for the individual patient and any other interested parties involved in the person's care. Informed consent is the cornerstone of surrogate decision-making. Individuals with disabilities have the right to informed consent, like everyone else. Everyone should expect informed consent to include a full explanation of the proposed procedure, a description of risks and benefits, information regarding the level of discomfort and any effect on functioning, the disclosure of alternative procedures or options, and consent is a voluntary decision and people have the freedom to withdraw consent at any time. Adequate information should be provided to make a decision about the treatment or procedure. The healthcare provider needs to make sure that the individual understands the information in order to make a capacitated decision, with full knowledge of the risks, benefits, and alternatives. A healthcare provider may evaluate understanding by asking the patient to repeat the information back in his or her own words. The patient should be able to provide a plain language description of the treatment, the risks, benefits, and alternatives to the procedure. Individuals who provide consent can withdraw consent at any time. For example, a person can decide that they don't want to move forward to the procedure and withdraw consent. The next section will provide an overview of the SDMC process. The surrogate decision-making process begins when the declaration form is submitted by the provider or hospital requesting an SDMC consent for treatment. All cases are processed through the central office in Schenectady, which involves a nurse documenting and reviewing the case. When the information in the case is complete, the case is sent electronically to a regional SDMC contract office, which is the third step in the process. The regional contract office will then schedule the hearing in a timely manner with the providers and Mental Hygiene Legal Services, or MHLS, and then reach out to volunteers in that particular region to obtain 4 volunteer panel members to serve at the hearing. These 4 volunteer panel members will receive the case packet prior to the hearing to review the information and formulate questions before the hearing. The hearing is then held, which is the 4th step in the process, and the last step involves a decision being issued. When the declaration is received, SDMC will confirm that the individual qualifies for the SDMC program. A person becomes eligible for SDMC major medical decision-making if they are or have ever been in a residential program or receive services from a program operated, licensed, or funded by OPWDD, which includes case management, family care, and day programs. Individuals do not need to be currently receiving services to qualify. A person can also qualify for SDMC if they have ever had an inpatient admission to a psychiatric facility or inpatient treatment at an OMH facility, or previously received treatment in a residential alcohol or drug treatment facility operated, licensed, or funded by the Office of Alcoholism and Substance Abuse Services, or OASIS. In addition to being a current or former service recipient in OPWDD, OMH, or OASIS, SDMC would also need reason to believe that this person lacks the capacity to consent or refuse medical treatment. A capacity assessment completed by a licensed mental health professional is included in every packet submitted to SDMC. If the individual is evaluated and deemed to lack the capacity to make his or her own treatment decision, the next step is to determine whether there is a legally authorized surrogate or decision maker that is available and willing to make the decision on this person's behalf. A legally authorized surrogate will be discussed in greater detail in Module 2. If there is an available and willing surrogate, SDMC will not make the decision. The surrogate will now make the decision. Therefore, individuals that are eligible for SDMC are those who are not able to provide consent for themselves and do not have a legally authorized surrogate available and willing to provide consent on their behalf. When the SDMC program was being developed, the legislators wanted volunteer panel members with expertise and sensitivity and interest in the care and treatment of people with disabilities. They decided that people who would be good decision makers should consist of 1 member of each of the following categories: a New York State licensed medical professional, an attorney admitted to the New York State Bar, an advocate and a family member, or a person with a disability. New York State licensed medical professionals can include a nurse, doctor, dentist, physician's assistant, occupational therapist, or OT, or someone who has a license to practice healthcare in New York State. Attorneys bring their decision-making skills and experience to the table with knowledge of ethics and the law. Advocates are individuals that work in the disability field that support people with disabilities in a professional capacity or volunteers that assist people in programs or service systems. Another panel member that needs to be represented is a family member or a person with a disability. These volunteer panel members bring a different perspective and are valuable in helping to make a decision for the individual. The declarant is the person who submits the written declaration to SDMC. The regulations don't designate or limit who may act as the declarant. The declarant may include any provider of health services, the director of the individual's residential facility, or a relative. The declarant should be familiar with the individual's abilities, family status, and medical needs, and can explain what procedure is being requested and why. The declarant is the point person for all SDMC contacts and should also attend the hearing. In order for SDMC to consider a case, a written declaration with the 4 forms for major medical treatment must be submitted. The declaration must state that the individual does not have the ability to make his or her own decision, does not have an authorized surrogate, and the reasons the proposed medical treatment is believed to be in the individual's best interest. SDMC is required to send notice to all potential surrogates at least 5 days before the hearing is scheduled, unless the case is expedited. In cases that are deemed expedited, where the care need is imminent but does not rise to the level of an emergency, the notices still must be made, but only as soon as practical. Therefore, the 5-day notice of hearing would be waived. If a surrogate is unavailable or doesn't respond to the provider's attempts by phone or mail, by law, SDMC is still required to send the notice of that hearing to ensure that due process has been followed. If they don't respond to the notice, SDMC will continue to move forward with the case. The SDMC hearing may proceed if the authorized surrogate affirmatively waives his or her right to make the decision, or the authorized surrogate fails to respond to the notice of hearing. When an authorized surrogate fails to respond to the notice of hearing, the panel can consider the person's preferred surrogate to be unavailable and may proceed to make the determinations. If a potential surrogate who was thought to be unavailable were to unexpectedly become available or object to SDMC proceeding, SDMC would defer to such individual as authorized by SDMC statute, and the surrogate would make the decision. SDMC consent begins the day of the hearing and is typically valid for 60 days. However, the panel can extend the consent beyond 60 days if necessary at the time of the hearing or even after the hearing if there are unforeseen circumstances. Consent is not issued to a specific provider or physician. The consent is for a particular procedure to be performed on a particular individual, not for a specific doctor to perform the procedure. Additional consents are not required for admission, diagnostics, or anesthesia, which are all included in the SDMC consent. SDMC does not sign a separate hospital or physician consent. The language in the consent allows the physician to make the anesthesia decision at the time of the preoperative screening. A discussion may occur at the hearing about IV sedation, but on the day of the procedure, after a preoperative screening, the physician and the anesthesiologist may decide to use general anesthesia. Very often, hearings may grant consent for days or weeks prior to the anticipated procedure. The SDMC consent permits the physician to use the most appropriate anesthesia method on the day of the procedure. SDMC consent also allows a physician to move forward with a related procedure, even though it may have not have been specified in the original declaration. If it is related to the treatment, the physician can proceed as necessary according to his or her medical judgment. For example, if he or she sees a polyp during a colonoscopy and the consent didn't note possible polyectomy, it will be covered by that consent. Related treatment or diagnostics that are recommended after the procedure is performed will also be covered under that original consent during the consent period. The next section will cover treatment and procedure options. The SDMC statute and regulations identify a specific range of treatments and procedures eligible for SDMC consideration. This includes any medical, surgical, dental, or diagnostic intervention or procedure which involves treatments with a significant risk, the use of anesthesia, or any significant invasion of bodily integrity requiring an incision or producing pain. Examples of treatments with significant risks would include colonoscopies and endoscopies because there is a risk of a puncture or bleeding complications with those procedures. It also includes diagnostic procedures or scans, such as computerized axial tomography or a CT scan, or an MRI magnetic resonance imaging that use contrast dyes. The use of anesthesia, for example, an IV, monitored or general include medical, surgical, dental, or diagnostic interventions or procedures which involve the use of a general anesthetic or anesthesia for any procedure which the doctor requires informed consent. For any routine care or treatment, such as a dental exam, a mammogram, a gynecological examination, that must be provided under sedation or anesthesia in order for the individual to cooperate safely, SDMC will provide informed consent. Any significant invasion of bodily integrity requiring an incision or producing substantial pain, discomfort, debilitation, or having a significant recovery period can include surgeries, anything invasive, or anything from a simple biopsy to open heart surgery. SDMC can also provide consent for any other treatment or procedure which, in the physician's opinion, requires informed consent. This is a catch-all category, which allows the physician's professional discretion to determine if a particular procedure requires informed consent. If the physician will not proceed without informed consent, then SDMC will accept the declaration for the procedure based upon the physician's medical decision. Chemotherapy and hospice require informed consent. In 2009, SDMC was granted jurisdiction through an amendment to the guardianship statute, which authorizes specially trained SDMC volunteer panel members to make end-of-life decisions to withdraw or withhold life-sustaining treatment for the individuals with intellectual or developmental disabilities. SDMC does not accept end-of-life cases for individuals served by OMH or OASIS. Routine medical procedures are excluded from the SDMC process. This includes routine medical care or blood draws, and also dental care performed under local anesthesia. If an individual is cooperative with their routine dental examinations, their cleanings, or fillings with Novocaine, they do not require SDMC. These are considered to be procedures that are routine with minimal risks. However, there are exceptions. One exception would be if there is something specific or unique to this individual that presents a higher risk. For example, if a procedure that is considered a routine procedure, but an individual has a higher risk because of a particular condition or another comorbid diagnosis, SDMC might be able to consider the case. Another exception would be a routine dental evaluation if the use of anesthesia or IV sedation were used to facilitate compliance. SDMC is also excluded from considering emergency medical treatment. Essentially, public health law allows a physician to proceed in an emergency situation without delay when, in their medical judgment, a delay in order to secure informed consent would increase the risk to the person's life or health. Electroconvulsive therapy, or ECT, sterilization, or termination of pregnancy are excluded from the SDMC process. These cases would have to be addressed through a court process. SDMC does not have the jurisdiction to make any decisions regarding end-of-life care for non-qualifying individuals. SDMC's jurisdiction is restricted to only persons with an intellectual or developmental disability. SDMC volunteer panel members are considered public officers and have certain responsibilities. Volunteer panel members are public officers and have certain roles and responsibilities. The panel hearings are quasi-judicial in nature, and the role of the panel is similar to that of a judge in that the panel acts together to make a decision on behalf of the individual at the hearing. As volunteer panel members, it is essential to maintain your impartiality as a decision maker and observe standards that promote fairness by not favoring one side over another or coming to the hearing with a bias about the proposed treatment before the testimony is presented. Volunteer panel members should maintain the appearance of impartiality and neutrality by approaching each case without any preconceived ideas or biases. All interested parties have a right to be heard. Please ensure there is no conflict of interest with any agencies providing services for the patient. To avoid this, SDMC asks all volunteer panel members to disclose any affiliation or employment that may present a conflict on the SDMC panel information sheet. Volunteer panel members should also inform SDMC if their conflicts change. There is an expectation that volunteer panel members will conduct themselves in a manner that demonstrates integrity, fairness, and independence in decision making, so volunteer panel members don't want to have any potential conflicts of interest or bring in any other special interests that could affect independence in decision making. The decision making is strictly for the best interest of the patient. Volunteer panel members may not accept other employment which will impair their independence of judgment. If volunteer panel members have a conflict of interest with the agency submitting the declaration, or if they have a business relationship which could be a conflict of interest, they must recuse themselves from the hearing. Volunteer panel members may not disclose confidential information or use their position to secure unwarranted privileges or exemptions. Volunteer panel members may not engage in ex parte communication, which is a communication involving two or more parties regarding a proceeding without including other interested parties. If there are any legal disputes following the SDMC hearing as a result of the decision issued, Volunteer panel members will be defended and indemnified as long as you are acting within the scope of your authority as an SDMC panel volunteer and there has not been any misconduct or criminal behavior. Volunteer panel members would be defended by the Attorney General if there were a civil or criminal action based on acts or omissions committed while acting within the scope of authority as a panel member. Private counsel would be provided if the Attorney General is not able to defend you due to a conflict of interest. Volunteer panel members will not have to pay any costs, attorney fees, fines, or penalties as long as the injury or damage was not a result of intentional wrongdoing or recklessness. For example, volunteer panel members cannot disclose confidential information. If he or she does, that would be considered reckless and not be entitled to defense or indemnification. If you have any questions about the SDMC process, please call 518-549-0328 or email sdmc@justicecenter.ny.gov. The Justice Center maintains a distinct toll-free information and referral or INR line, which is 1-800-624-4143, 8:30 a.m. to 4:30 p.m. Monday through Friday. Staff responds to calls and email inquiries regarding disability issues, including disability rights, legal assistance, housing, employment, assistive technology or AT, healthcare, and any other disability-related questions. Specifically, staff connects individuals with information, provides technical assistance and/or referrals to programs or services, and solves problems for individuals with disabilities, parents and guardians, advocates, employers, and providers. For information about the Justice Center, please visit the website at www.justicecenter.ny.gov.